Judge, my camera's not working for some reason. This is Dale Hayes for NickCarter. I'm trying to.
Good morning, Your Honor. This is Margaret Mabey for Plaintiff Ashley Rabb.
Good morning. I heard from Mr. Hayes and Miss Mabey. Is there anybody else on for Ruth versus Carter?
Judge, I'm going to exit and come back. All right, see if that works.
Okay.
There may be staff from my office listening. That's all, Your Honor.
Okay. Do we have local counsel for you on?
We don't. Unfortunately, Mr. Kawai is in trial. He was unable to make it, but I am here on his behalf, and I have some notes from him as well.
Let's see if Mr. Hayes gets back.
All right, got it. Thank you. All right, sorry about that, Judge.
Okay, I can hear and see you now. Before we go further, we apparently don't have local counsel for one of the parties on.
Just to finish stating my appearance, Your Honor, I believe some of my colleagues are observing online, including my.
Oh yeah, no, you're fine. It's the other side.
Okay, and my client NickCarter is also observing. Thank you.
Okay.
And I apologize, Judge. I am pro hoc in the case, and Mr. Kawai was unable to make it to this particularly scheduled hearing.
Well, I'm not I'm not sure what I'm supposed to do other than I can't go forward without local counsel.
Who are we waiting on, Margaret? Margaret, you know who we're waiting on?
I believe the judge is waiting on Mr. Kawai, but Mr. Kawai is not available today.
Oh, Your Honor, I believe Miss Mabey's properly pro-hocked in.
I have been. Yes,
Well,
Your Honor.
no, I don't doubt that. The issue is you don't have local counsel here as well. That's the issue.
It's a pretty big law firm, Margaret. Is there any way you can call somebody really quick?
Let me see what I can do, Your Honor. I apologize for the misunderstanding.
Judge, we'll certainly accept the default.
We'll trail you. We've got, I don't know if anybody's here, but we've got a couple other cases.
Thank you, Your Honor. I apologize. I'm working to get Mr. Kawai on the line right now.
Morning, Judge. Dale Hayes on behalf of defendant counterclaimant Nicholas Carter. Once again, I have other colleagues that are observing online, including my partner, Leanne Wakayama.
Good morning.
Good morning, Your Honor. Margaret Mabey here for Plaintiff Ashley Rabb, and we were able to get my colleague John Kawai on the line as well, though he is in trial.
Okay. Mr. Kawai, are you there?
Yes, good morning, Your Honor.
Good morning. Okay, so to be clear, the rule requires local counsel to be here. Zoom, of course, is totally fine. Okay, so thank you. So we've got, I think, two motions on. I'll tell you what I'm inclined to do on both of them. The motion to compel discovery responses and for sanctions, I'm inclined to grant that in almost its entirety, except to reduce the amount sought. Certainly reasonable fees and costs are permitted, but I don't think the extra amount that was requested would be. So I'm inclined to grant that $5,000 in reasonable fees and costs. I would, that $5,000 would include prepping for today and appearing for today, essentially. So inclined to grant that one. There's certainly no good cause shown for the lack of responding. On the Motion for partial summary judgment. I'm inclined to deny without prejudice because genuine issues of material fact exist. You know, the pleading was on or about numerous times, not simply on. I understand that Ms. Ruth may have contradicted herself in the deposition, but that's, you know, fair game for impeachment and cross-examination. I don't think it's cause to grant summary judgment on that particular claim. I would also point out the counterclaim states, you know, she traveled to the Manhattan property once in October 2003 for a lengthy stay, or words to that effect. So inclined to deny the summary judgment motion for those reasons. But let's talk first about the motion to compel. If you're okay with the preliminary, you could save for rebuttal, or you could argue me out of my inclination, Mr. Hayes.
No, Your Honor. I'll reserve. My only comment is I know that the rule provides or permits you to award the fees against both the party and the law firms. And that's the only clarification I'd ask, and then I would reserve for rebuttal.
Oh, thank you very much.
Good morning, Your Honor. Thank you so much for your time, and I appreciate the preliminary findings. Both my office and Mr. Kawai, you know, happy to fall on our sword for this issue. There was vast miscommunication and a lack of clarity. We did eventually and did respond indeed to the discovery requested, and so that has already occurred. There's no need to compel that. And you know, had there been a phone call to our office, I'm certain we would have been able to sort this out without need for your honor, but we're very happy to do what we can to make this right and make sure that we can sort out any issues going forward without having to involve you.
Thank you very much. Any rebuttal?
I'll also note that my client was partially unavailable during that time period, and so was my office, and so we sincerely apologize to the court and to counsel for any issues in delay.
Thank you.
Obviously, Your Honor, while I don't appreciate the jab, the only comment I have is that we do reserve rights relative to the responses. This was a motion to compel the responses. We did my mission later this afternoon is to send them a 234 on the actual responses. So to the extent that counsel's argument says that issue's been resolved, clearly it hasn't, but I'll submit on this unless your inclination has been wavered in any way.
No, thank you very much. So the inclination remains the same. So the court grants the motion to compel discovery responses from Ashley Rep and for sanctions in its entirety, except for the reasonable fees and costs being $5,000. And I'll leave it to counsel, Miss Maybe or Mr. Kawai, you know, as noted, that sanction can be awarded against the party and or the firm. Seems to me to be a firm issue, candidly, and not Miss Rep herself from what I read. So if you want to make it just against the firm, that's fine. If not, it'll have to be both Miss Rep and the firms. But no good for all the reasons in the motion and reply. And it's fair to point out, as Mr. Hayes did, this is without prejudice, of course, to follow up if necessary on the responses that have been provided post filing the motion to compel. But hopefully it'll work any issues out with that. But that's certainly, again, without prejudice. Is any follow-up on that? Mr. Hayes, prepare an order, submit it to Ms. Maybe and Mr. Kawai for review and approval.
Absolutely, Judge. Your Honor, if I may, on the MSJ.
Sure.
I appreciate your inclination, Judge. I'd like to try to sway you.
Okay.
You know, I know you're well versed with summary judgment, and I'm not going to rehash it, particularly given your inclination. I do want to point out some of the parameters of summary judgment law that kind of are pretty particularly relevant with this motion. Those are that first, the factual dispute has to be genuine. That's clear. And Aldabi and its progeny, which we cite to, are very clear, Your Honor, that a issue of fact cannot be created by contradictory statements of a party. That's exactly what we have here. Your Honor brought up credibility, and I would submit to you this is not a credibility issue, Judge. This is her testifying unequivocally that an event happened on this date. I disagree with counsel that it doesn't go to the elements of the claim. This is a battery claim. As Your Honor well knows, the first and second elements of a battery claim are the intent to make contact and actual contact. And my client certainly could not have contacted her if he was 2,500 miles away. I think the credibility issue lies with the two first alleged assaults, notwithstanding Ms. Rep's sworn statements to law enforcement that she wasn't assaulted way back when. That is a scenario where you have my client saying it didn't happen and you have Ms. Rep saying it did. But this is a different animal, Your Honor, in the sense that she's committed to this happening on this date. And the only reason we brought up the complaint allegations, Judge, and that's the third parameter of summary judgment law that I wanted to focus Your Honor on today. And that this is not a 12B5 motion, Judge. They brought up complaint allegations and notice pleading. This is a 56 motion, and summary judgment law is very clear that you cannot withstand summary judgment by relying on the allegations of a pleading. And these are unverified allegations, keep in mind, Your Honor. The only reason we brought the complaint allegations up, Judge, it was completely misconstrued and then snowballed by counsel, was because they made arguments that my partner somehow tricked Ms. Rep into this date with some kind of legal wizardry at the time of her depo. And she's been handcuffed and married to this date. She put it in her complaint. And I understand on or about, and I get complaint allegations. Trust me, Judge, I totally understand that's legal argument and not evidence. But then when she backs it up with sworn discovery responses, she testifies in her declaration that everything she said in her complaint was accurate, that was used in connection with the anti-slapper meetings, which, by the way, she prevailed at. We're up on appeal now, right, Your Honor. She admitted in her request for admission, this battery happened on this date. And then for an hour, my partner didn't trick her, but gave her every opportunity to say, hey, this is 20 years ago. It could have been a different day, but she did not waver. She said she was absolutely certain about her timeline. She called people that challenged her timeline liars. These are direct quotes from her deposition transcript, Your Honor. And for them to argue or to come to the conclusion that it's now a credibility issue, I just think that it turns summary judgment on its head. It turns Aldabi on its head, and it allows, a conflicting sworn statement, really, just pages and pages and pages of sworn statements to be conflicted by, now that you objectively show me that I'm a liar. Hey, maybe I lied, but hey, it must have happened on a different day, Your Honor. And all we're really asking for is that you grant a summary judgment with respect to that third assault, which she testified unequivocally about and has presented no evidence, Judge, at all that it occurred beyond her contradicted testimony, which again cannot be used to withstand summary judgment. So I'll submit on that, Your Honor. But I think that's the main distinction here, is that this is not a credibility issue, Judge. The first two are credibility issues. Granted, we're not in here. That's why our motion is focused. This is a material issue of fact. There's no genuine issue. She was married to this date over and over again, and she cannot come in here now and say, oh, he didn't batter me, but he must have battered me some other time. And that's why we feel summary judgment as it relates to that third assault and any damages arising therefrom is appropriate in this case. Thank you, Your Honor.
Thank you very much. Any opposition?
Yes, Your Honor. The complaint itself states that the date was on or about. The idea that Ms. Rep was ever married to this specific date is absurd. She's never made those claims. In the exact deposition transcript that opposing counsel is referring to, she mentions that that's when she believed this occurred. She put together a timeline. She is expecting that around this date in October in that year, decades ago, is the date that this occurred. And so the idea that she somehow lied or provided any kind of testimony that's contradicting is absurd. She committed to dates that she thought were appropriate, and when pointed out that he was not there, she completely agreed that those dates were always and had always been approximations. Similarly, assuming arguendo that these dates somehow do create a contradiction by my client, this does not dispose dispose of any of her claims because the battery took place in the first two instances. The idea that whether or not the third battery took place, the third sexual assault took place, does not dispose of any of her claims against the defendant. A summary judgment determination as to that third assault would be a factual determination. And as I mentioned, our client has maintained from the beginning that this assault occurred in October, that it was an approximation of the date that it occurred, and she continued that throughout her deposition. The questioning that occurred regarding that date was under the assumption that every question anticipated that it was an approximation, which is exactly what it states in the complaint.
Thank you very much. Any rebuttal?
Just brief, Judge. Once again, that is simply not true. They had a chance to file an opposition. You know, we attached all of these discovery and sworn testimony and responses to our motion. You have her request for admission response. You have her deposition testimony. They keep talking about the complaint allegations. I have no, this is a 56 motion, Your Honor. I have no idea. I wish we never would have brought it up in the initial motion, Judge. But again, we only did it to show that we did not, I think the word counsel used was embed. We did not embed this date in her mind. She came to the table with it. And then we just said, okay, listen, are you sure about this date? And she said, yes, over and over and over and over again. She did not say around that date, as counsel just said. We attached the transcripts. She was absolute about her timeline, called others liars that put it into question. And, Your Honor, I really don't understand the last argument she made relative to, well, he raped her twice. So, I mean, I guess that means if you being raped once is the same thing as being raped 100 times. I mean, she's alleged 3 separate events of sexual assault here. We've completely disproven one of them. And to suggest that that doesn't matter because 2 of the other ones have been established. First off, they haven't been established. By her own admissions, they were consensual. Her own mom said she went there to have sex with Nick, but that's besides the point. But, you know, more importantly, Your Honor, it's offensive. You know, as a man, I can't imagine a woman hearing that the third assault doesn't matter because there's 2 other ones being alleged. I mean, I don't know about you, Judge, but if Mike Tyson punches me twice, I don't want to get hit a third time. You know, 2's enough. And I don't want the added damages a third one may bring. And that's just kind of a metaphor for the argument that was just made that it doesn't matter because there's 2 other assaults being alleged. So I'll submit on that. They've clearly alleged 3 separate sexual assaults, and we've proven that the third one cannot withstand summary judgment. Thank you, Your Honor.
Your Honor, if I may respond.
No,
Thank
but
you.
thank you for asking. The way it goes, so to be clear, there are rules. So one of them, to reiterate, is local counsel has to appear at all hearings and trials. Another one is, you know, opponent movement, and unless I ask for more, that's what we've got. So court sticks with its initial inclination, which is to deny Mr. Carter's motion for partial summary judgment without prejudice because genuine issues of material fact exist. The contradictions or alleged contradictions subject, of course, to impeachment, cross-examination, etc. But there are certainly genuine issues of material fact that lead to the denial. So those include, but are not limited to, the pleading lists out on or about, not on. The counterclaim, paragraph 184 in the counterclaim avers that Ms. Rep traveled to the Marathon property once in October 2003 for a lengthy stay. So that, of course, supports genuine issue material fact as to the timing. I would also add to that her deposition testimony, clarifying, whether you call it clarifying or contradicting, it's still, either way, it's a genuine issue material fact, where she clarifies, you know, it's quite possible I may have gotten the date incorrect. And also she states she's not changing her testimony. She'll agree she's not perfect. She may have gotten the exact date wrong, or she's been fairly good with getting exact dates. All of that just shows, you know, question for the jury And whether October 27 or on or about October 27, question for the jury, and certainly, subject to impeachment and cross-examination, but there are genuine issues of material fact there. So Ms. Maybe prepare that order, put the reasons in there, submit it to Mr. Hayes for review and approval.
Thanks, Judge.
Thank you, Your Honor.
I'm sorry, Your Honor. I just wanted to let the court know that my not being here earlier was that's on me. And so I apologize to everybody for the time wasted. And as far as the motion to compel, I think Ms. Maybe and I are in agreement that the order should be for sanctions against the law firms.
Okay, sounds good. Thank you.
Thank you so much.
Thank you, Your Honor.
Thanks, Judge.
Thank you.